Cove Productions presents the Solo in South Philly podcast with your host and local legal whiz, with knowledge, Mark Kachi.
What's good, everybody? We are back with season 2 of the Solo in South Philly podcast. Season 2 is called I Need a Lawyer. I will be speaking to lawyers that I reach out to when I need information or advice. Today's guest is Marla Samora. Marla Samora is a Central Valley native, born and raised in Porterville, California, where she became fluent in Spanish. Marla attended Columbia University for undergrad and Temple for law school. Marla currently represents clients in their immigration cases before U.S. Citizenship and Immigration Services, the Immigration Court, the Board of Immigration Appeals, and in federal district and circuit courts. Her practice focuses on minimizing the immigration consequences of criminal convictions. She has experience in arguing that clients' criminal convictions do not trigger adverse immigration consequences, as well as defending clients who are currently in removal proceedings as a result of certain convictions. Marla also has experience in litigating asylum claims, waivers, and adjustments of status before the immigration court. She also has experience representing clients in complex affirmative applications such as naturalization, adjustment of status, and other matters. Prior to opening her own practice, Marla worked at Vanderhoot LLP, which is one of the nation's leading immigration law firms, as an immigration associate, where she worked on complex removal cases and affirmative applications. Prior to joining Vanderhoot, Marla previously split her time between the Nationalities Service Center and the Defenders Association of Philadelphia Immigration Unit, where she focused on immigration consequences of criminal charges and convictions. Marla also assisted clients at NSC who were facing removal in immigration court, applying for affirmative relief, naturalization, and with family-based immigration applications. Let's welcome Marla to the program. Marla, thank you for joining us.
Hi, thank you for having me. I'm really excited to be here.
Let's talk about immigration law. But before we do, why don't you tell us, how did you get into immigration law?
I ended up in immigration law basically because I am a child of an immigrant and my father is a child of immigrants. And I grew up in an area that it's called rural California, Central Valley, where there's a ton of migrant workers. And so, immigration was just part of my life. It was always there. And after I graduated from college, I realized that I really wanted to be in an advocacy role for non-citizens because they're such a vulnerable population. And so when I started looking at law schools, I knew I was going to go to become an immigration lawyer. I was hoping to be in the nonprofit sector, which is where I did start my career in Philadelphia. I went to Temple Law, go Owls, which had a great public interest program, great access to nonprofits. And in addition to that, it's just a really fascinating area of law. It touches everything in your life. Immigration, it touches the economy, it touches public safety, it touches so many things. And so it's just something that I found really appealing. I found it really rewarding. And so that's my main focus.
That's awesome. The added benefit is you aren't married to a state. I can't think of any other area of law that works that way. It's like the perfect storm. All the law is federal. So unless your client's immigration case intersects with an area of state law, you're free to practice in all 50 states without sitting for the 50 different bar exams.
Yeah, so the Immigration Nationality Act is a federal statute, which is why it's a federal practice of law, which means you just need to be licensed in a state. The majority of people that I have found tend to be licensed in the state where they are practicing because there is overlap with a lot of other state laws, but I'm barred in California. I started my career in Philadelphia, working as Padilla counsel, immigration advice at the Defenders, and also doing immigration work at a nonprofit Nationality Service Center. So it's one of those areas where you're absolutely right. You can literally practice it anywhere you go, so long as you have a bar license. There does tend to be some state law practice, if you're doing sort of mandamus lawsuits against the government, if you're going to appeal at, a federal circuit court, those you'll need to be licensed in the state, or you'll need to be a friend of the court or pro vice, so that you can represent clients at that level. But yeah, it's kind of awesome. You can really move around if you need to. I have a national practice, so I have clients in, I think, at least 8 or 9 states. And I sometimes travel to those states. I sometimes do things remotely, but it's one of those things where you can just practice in whichever state you want, because the Immigration Nationality Act applies to all 50 states.
I've tried to ask bankruptcy attorneys to explain why it doesn't work this way in bankruptcy court. The bankruptcy code is federal. The only thing I can think of is that electing a state versus federal exemption is seen as making a legal conclusion under a particular state's law.
So it's fascinating because even within immigration law, even though it applies federally, the statute, you're going to see differences in case law depending on what circuit you're in. So the Ninth Circuit has their own decisions that in some instances tend to be more favorable, and in other instances you'll have other circuits that are more favorable depending on what area of an Immigration Nationality Act they're looking at. So that's why you'll see a lot of cases go up to the Supreme Court, because these circuit splits develop. So that does sort of imply that you will need, if you're practicing immigration law, especially if you're going to the appellate level, you do have to be sort of licensed and have specialized knowledge in that circuit's case law as it relates to immigration.
Got it.
Yeah. So I don't know if that touches although it's federally, there is still sort of state or circuit specialties.
Right. Okay. So in terms of, immigration law, there's a lot to immigration law, but let's talk about what many people are interested in. What are the different paths to residency?
So there are several different paths to residency. There is the category of family-based immigration, which is you're being immigrated through a family member. There are specific categories that allow you to do that. So it's not like you can apply for any family member. And then there's employment. There's humanitarian types of relief. And then there's also sort of the diversity lottery that is trying to encourage immigration from certain underrepresented countries in the United States. So with family-based immigration, you're looking at immediate relatives and or spouses, children under 21, or unmarried children who can immigrate. So a lot of times I'll have questions of, can I bring my cousin over? Can I bring my grandmother over? And the answer is no, because there's no actual visa category for those family members.
Let's talk about the humanitarian side first. What is asylum, and who are refugees?
Sure. So you have asylees and you have refugees. So refugees, that's all adjudicated outside of the country. And so once they enter, they are refugees. And then after a year of their physical presence here in refugee status, they can apply for a green card. For asylees, that's not available outside of the country. They actually have to avail themselves here and be physically present. So I'm sure you've heard a lot of stuff about Title 42 and, the Wait in Mexico program and all of these other things that were happening during COVID that was impacting asylee applicants directly. It was because these people were availing themselves at a port of entry, trying to get in line so that they can enter, be paroled, so they can apply for this benefit that they're legally entitled to. And so with asylum, once you're here, then you have to make your case. You can either make it affirmatively or you can make it defensively. So affirmatively, you would go before the asylum office, and defensively is if you are actually placed in removal proceedings. So a lot of the recent arrivals who are here, they're most likely going to be applying defensively. For those who apply, who maybe are here on a student visa, or you came here on a tourist visa, and there's something happens in their country, or they realize that they can't go back for a protected reason. Asylum itself is actually a pretty complicated area of law. It's very, I would say, it's not equitable in how people receive it, because immigration judges have very disparate rates of approvals, denials. You have some courts where judges have a 98% denial rate, and other courts where they have a 80% grant rate. It matters if you have an attorney or not, which, in my opinion, is ridiculous, because this is supposed to be something that should be accessible to people who are fleeing their home country, who sometimes literally have nothing. They just come here with nothing. How are they supposed to be able to contract an attorney to navigate them through the system? But if you're looking at sort of what makes people eligible for asylum, they basically have to show that they have been persecuted or they fear persecution on account of a protected ground. That's race, nationality, religion, membership in a particular social group, political opinion, and that it's either the government or somebody the government is unable or unwilling to control, and internal relocation is not reasonable. So for some of them, they seem pretty basic, right? Religion. Yes, we've seen instances of that in history. We've seen, political opinion, those kinds of things seem to be a lot more straightforward. But there's this category of membership in a particular social group that tends to apply to quite a few asylee applicants. But that's where you really need an attorney, because you have to be able to craft and articulate what this group is, because this group has to be cognizable, it has to be visible, and even the requirements about that vary from circuit to circuit. But anyways, as you can see, there's a lot that goes into applying for asylum, and a lot of people who come either don't know the requirements, they don't understand the requirements, they don't have enough education to really advocate for themselves, and so you see a lot of people who have viable cases but end up getting ordered removed because they're just not capable of really presenting it to a judge in a way that shows they're eligible under the statute.
So let's talk about some of this stuff, unpack some of this.
Mm-hmm.
There's a lot of luck of the draw, it sounds like,
Mm-hmm.
but worldview, right? That this is something like I hear about a lot, that, I know a lot of Brazilians that are going through this, and they'll talk
Mm-hmm.
about how judges and the general public have this idea that Brazil is some resort, right, with beaches and soccer and partying.
Mm-hmm.
And while that may be in certain places, that's not what they're fleeing from, and it's often held against them.
Mm-hmm.
I've heard Georgians tell me that from the country of Georgia that
Mm-hmm.
they got what's going on in Ukraine as well, but people don't know it or understand it. And
Mm-hmm.
how do you combat some of that lack of worldview or distorted worldview, ignorance, all of the above?
So I sometimes see that with immigration judges, where they really don't have an understanding of what's going on in a country. When I do have an applicant from one of these places, Brazil, I have quite a few LGBTQ asylum cases from Brazil, because even though Carnival seems really festive and all of that, there's quite a lot of persecution of people of that community. So a lot of it is I do research and I create country conditions, and I brief and basically sort of write a poli-sci paper on what is going on in that country, to convince the judge that the country conditions support the fact that this person will be persecuted. And under asylum, you just have to show that there's a 10% chance of future persecution. It's not 90%, 99%. And there are some people who may not have been persecuted in the past, but based on just the fact that they're can be associated with a persecuted group, that itself could qualify for asylum. So, when I encounter people as they try to understand what's going on in like Central America and all these other places, I'm armed with that knowledge of, what actually is happening there and how oppressive these states are to the citizens there. And it's almost like, for example, there's a lot of like unspoken agreements to like leave tourists alone, because they know that if they don't, then that's going to cause more of a sort of conflict with government officials, because the government officials care about their image, right? And so if they see that happening, if they see tourists, that means then they'll have to really enforce their law against them. But you don't normally see that when it's a citizen who's being victimized or persecuted by like a gang or a cartel. So when people say like they just don't understand what's going on in other countries, if they're here and I talk with them, I mean, I do my due diligence. And if it's a country that I'm also like, I wasn't aware of that was what was happening, I make sure I research it before I give them my opinion as to how I think their asylum case would fare. So I get to learn a lot. I mean, it helped that I have a poli-sci degree, so I have written a lot of papers about countries. One of the greatest compliments is when a judge just basically steals all of your quotes from your brief and puts them in his written decision, which has happened, which is great. So it takes a lot of work. You sort of become your own country conditions expert, researching, doing all of these things and writing basically like a position paper on what's going on in these countries.
That's interesting.
Yeah.
So back to this asylum concept. Explain to me if I got this correct. I mean, at least the overarching philosophy behind it, right?
Okay.
So there's a danger, an enumerated danger that justifies an individual to either flee their country and come here or stay here, right? For fear of what's going on back home. And then the court kind of recognizes, almost like they do with an injunction, that there's a threat of irreparable harm if they get this wrong. So therefore, they allow the individual to remain here while the judicial process sorts all this out. Is that basically the underlying theories behind this?
Sort of. You're almost to the finish line. So people who have availed themselves for asylum are entitled to remain here during the adjudication of their application. Absolutely. And through the adjudication of an appeal to the board. When it gets to the Ninth Circuit, you have to get a stay. It's a little bit more complicated, but correct. So if they get granted asylum by a judge, they are an asylee. After a year, they can apply for residency. After being a resident for 5 years, they can apply for U.S. citizenship. So yes, they don't have to. For a while, there's this concept of. I mean, it's not for a while. Sorry, like that. There is this concept of a credible fear interview that is supposed to happen at a port of entry when somebody is first maybe caught or avail themselves to Border Patrol officer. They're supposed to be interviewed by a trained official, usually over the phone. And there they basically have to make sort of like a prima facie case of eligibility for asylum. So they kind of have to be able to articulate, yes, I'm afraid, or I've been persecuted. And it's because of these reasons, which are a protected reason, and my government won't help me. And if they're able to sort of make that prima facie case, they don't have to have necessarily physical corroborating evidence. It could be purely testimonial. So once they get past that credible fear interview, there's that prima facie sort of case that, yes, they have a credible fear, but let's actually then make sure that they meet every single part of the asylum statute for eligibility. And so that's what the judge will adjudicate.
Gotcha. And as an attorney, is taking this whole story and all this fear and sort of applying it properly, concisely, accurately, et cetera, et cetera, et cetera.
Yes.
Is there
easier said than done?
is there any instance in which there isn't a prima facie case, like an attorney puts forth a petition and then it just gets denied on the papers?
Um, so yes, so there are strict statutory requirements for asylum. For example, you have to apply within 1 year of your entry or within 6 months of some sort of exceptional or changed circumstance, whichever is later. Excuse me. And so oftentimes, if there is no justification for not meeting that 1 year deadline, the judge can just deny the asylum prong. There are two other protections that are similar to asylum, but don't actually lead to a pathway to citizenship. It's called withholding of removal and Convention Against Torture. So those are protections. You still have a removal order, but you're allowed to stay here and renew your work permit. It typically applies to people who miss the 1 year deadline and or who have either criminal convictions or, like statutory bars or associations that would make them ineligible for asylum. The burden is much higher. You have to show a 50% chance of persecution or torture as opposed to 10%, and it doesn't result in citizenship or anything like that. So there are instances where the 1 year deadline, the judge does not agree that they merit an exception to that. So that's something that could be denied before meeting an asylum application that can be denied before looking at the merits. In other cases too, one, there is a very, very serious consequence of filing a frivolous asylum application, and which basically means that you're either lying through your teeth on this asylum application, or it has absolutely no merit to it whatsoever. And basically you are forever barred from any immigration relief under the law. So you will never get anything after that. So you have to be very careful. So when I talk to my clients, I tell them, it's like, you need to be honest. Or a lot of times I'll get clients where I have to review their immigration file, and I'm seeing a lot of instances where I've found that there has been a frivolous finding. It's very serious, and that's why, as an attorney, you can't just file an asylum application without actually knowing what the basics are underlying that asylum application.
Right, like any other pleading, right? You're charged with putting some sort of due diligence into finding the accuracy within it.
Yeah.
So you talked a little bit about criminal convictions. Let's talk about that a little bit. So let's imagine you have a person that has their asylum application pending, and they get into trouble with the law while they're here. Explain how that intersects and how that can jeopardize, or what to do in that situation.
Sure. So asylum is still a discretionary form of relief. So the judge can look at any convictions to determine whether you merit that discretionary finding. There are certain crimes that are a statutory bar to asylum, such as if convicted of an aggravated felony, which I know to criminal defense practitioners out there, they're like, what is that? An aggravated felony is specifically defined under the INA, and there's a nice little list of what is an aggravated felony. It's a crime of violence for a sentence of a year or more. It's drug trafficking. It could be certain fraud crimes. So there's quite a long list. An aggravated felony would be an absolute bar to asylum. So you have to be very careful of whatever your client is charged of. If it's something that's going to fall underneath that, then you really have to advocate for them to find some other crime that won't be a statutory bar. You might still have to plead guilty to something, but at least you can argue that you still merit a positive exercise of discretion. The other bar is a particularly serious crime bar. So it could be that maybe you have a battery conviction, but you were originally charged with attempted murder as well. But for whatever reason, that charge got vacated. The immigration judge actually can basically relitigate the facts to determine whether the conduct underlying your convictions merit this particularly serious bar concern. So that would be another bar for asylum. So Again, there are still bars.
Let's go back to that example for a second. Someone gets charged with a crime, gets a great attorney, and the charges get dropped. The judge in immigration court can say, I get that the application of the fruit of the poisonous tree doctrine in criminal court works, but that doesn't negate the fact that this person is a danger to our society.
Yes. So a judge can still look at those things. Absolutely. Which is interesting because you would think, I'm sorry, go ahead. No, it's just that you would think that that this immigration judge should not have the authority to relitigate a criminal case because you don't have the same sort of due process protections that you would have in criminal court. And I think that's where the difference is, right? In criminal court, the burden is on the district attorney. In immigration, the majority of the time, the burden of proof is on the applicant. There are other instances where the burden of proof is on the government, such as if they're trying to strip somebody of their green card or if they're trying to strip somebody of their asylee or refugee status, then that's the government's burden. But a lot of the time, the non-citizen is the person who has to meet the burden, which means that they have to put forth certain evidence in order to convince a judge. And sometimes that evidence is not great. For example, I've had a client who he was able to plead down to a reckless, but the underlying facts of the police report are really bad. And the government wanted the police report in there. I, of course, objected, talked about hearsay. Hearsay rules don't apply in immigration court, unfortunately. Talked about unreliability of the victim, of the witnesses, that, this is not something that a person can be solely convicted on, that there's other due process, and he was clearly only convicted on this lesser statute. But the case is still pending. I mean, the judge is asking me for more discretionary documents because he's seriously concerned. So that's an instance where you have somebody who was, pled down, but they're introducing a police report and the judge treats the police report as gospel. And it is incredibly frustrating.
Well, what about this example? Domestic violence. It's common for someone to commit domestic violence, then the victim reconciles with the assailant and refuses to testify. In this situation, the charges will get dropped and you'd have a record that reflect heinous charges, but no convictions. Do you think this would be an incident where it would be fair for the judge to independently look at the evidence?
I suppose, but that's presuming that you're having reasonable, immigration judges aren't actually even judges. They're not Article 3 judges whatsoever. So I think that sort of makes the system a little bit more challenging because you can have police reports that are completely unfounded, and you can have instances where something is really exaggerated, and in that case, you have a situation where you're going to have a judge who's going to just believe that this police report is gospel, and refuses to look at the nuances of how that police report came to be. I have a good example of this. I have a client who was convicted of a sexual abuse against a minor crime. But when you look at the actual records, it was very obvious that the actual abuser here was her boyfriend. She was 13 and her boyfriend was 22. And this was a conviction this was a crime in the 80s or 90s. And when you look at it on a whole, the victim had accused multiple people. First, she accused her father, then she accused this other person, but then it was discovered that her father wasn't there, etc. And so my client just got convicted. But by the time I got his case and we were litigating it before the immigration court, he testified and he had a very compelling testimony. He had no other criminal convictions, no other issues. And even the judge made a finding that she believed he was a victim of a racist judicial process. So those are sort of the things that you have to combat when you think about relying on police reports only instead of on actual convictions that have been proven in a court of law where our due process rights are present, and the DA has to comply with these constitutional due process rights.
Yeah, and I think one of the hard things as a criminal law attorney is you have to understand the implications of accepting a deal, as you mentioned, when you do have immigration clients, and I guess it should be part of your intake and checklist, like, would this?
Since 2012, the Supreme Court said in Padilla, there is a affirmative duty to investigate your client's immigration status and to properly advise them of the specific immigration consequences that would apply to them if they plead guilty to the charges, so that they can make an informed decision about what they want to do. So it absolutely should be part of every criminal defense attorney's repertoire to either have an immigration attorney on call, which I would recommend, or, if you're particularly interested in immigration, is what we call it, really specializing yourself and like becoming familiar with all of the processes. It's a very complicated area of law. A lot of immigration attorneys don't even touch crimmigration. And so you have to be really sure that somebody knows what they're doing. And the reason why is because you're having to compare state statutes to federal definitions of crimes. And so there's sometimes overlap, and sometimes the state criminalizes more conduct in the federal statute. Sometimes the federal statute criminalizes more conduct than the state statute. When the state statute is criminalizing more things than the federal statute, that means that you could be convicted of something that's actually not under the federal scheme, which means that there's no immigration consequences. So part of my job is comparing statutes, the state statutes, to the federal definitions to determine whether the statute actually meets that requirement. There's a whole process in determining what consequences the statute carries, and attorneys have been working on charts. If you look at your state, oftentimes there'll be a chart there. I worked on the chart in Philadelphia for the Philly Defenders, which looks at the statutes and explains what the consequences could be. It's obviously something that is a starting off point. You should still research because the law is changing all the time, but it's incredibly complicated. So, people here, I have clients all the time and they're like, oh, well, it was just a misdemeanor. I'm like, you know what? Some misdemeanors have greater consequences than serious felonies. It makes no sense. Anytime I talk with any criminal defense attorneys, they're just like, this makes no sense. You want me to plead him to a strike? And I'm like, yeah, that's going to be better for him. It'll satisfy the DA. He won't have the immigration consequences. It's way better than this misdemeanor that you might plead to, which will actually make him deportable. And they just are like scratching their head, not understanding, like, okay, this is crazy, but I guess I'll do this. And so that's why it's so important for criminal defense attorneys to consult with immigration attorneys, because oftentimes it doesn't make sense to them. And so you really need to have that expertise and that advice when you're advising your client. I mean, most of my clients have told me I would have spent years in jail if it meant that I wouldn't be deported. So if you hear that, you can only imagine, like, okay, this is incredibly important to them to be able to remain in this country, to the point where they'd be willing to take a conviction with a sentence that would make them spend a significant time in custody. So that's the disconnect, again, between sort of the federal and the state interplay of laws. So it's very evident in immigration. Another place where it really shows up is the fact that, states are decriminalizing marijuana, and it's still a federal crime. It's still considered a controlled substance offense. It's still a crime that could make you deportable. it's still a crime that could make you inadmissible. So clients who are like, oh, well, it's legal, right? So that's not a big deal. It's like, no, if you're smoking marijuana and you are not a citizen of the United States, this will come up and it could be an issue. So people have to be very careful who are non-citizens when they're going to a state that has recreational marijuana. Countries are different though. So if you go to Canada, you're fine because it's legal in Canada and we're not dealing with the federal system and the state system. But yeah, so those are again just examples where it just doesn't make sense.
Wow, that's really interesting, and these are good tips to let other people know about. Mm-hmm. Let's talk about another concept that I've recently come across, and that's the special immigration juveniles. And I see it as a party that the law has contemplated that could be in need of help, and they've carved out a way for them to do so.
Yes. So the special immigrant juvenile visas are for minors, depending on your state. So again, this is another interplay between state and federal law. You have to get a custody order or a guardianship order in your state through the family courts first. That's the first step for a special immigrant juvenile visa. And in obtaining that order, you have to demonstrate that this child was either abused, abandoned, neglected, and that it's not in their best interest to return to their home country. There are very specific findings for a special immigrant juvenile visa when you're doing these court orders. And in, like, for example, in the state of California, you can do it all the way up until you're 21 years old. In other states, the cutoff is 18, which means you have to get that order before they turn 18. If you don't, they're out of luck. Or they move to California and then they get it before they turn 21.
You want to hear something interesting out here, what we're dealing with is out here in Philly, there's a few states bunched up together. So in Pennsylvania, it's 18. In Jersey, it's 21. So you could have someone that lives on the wrong side of the river and that ship has sailed.
Exactly. The other requirement is once you get that order, then you have to actually file this self-petition for the special immigrant juvenile. And to backtrack a little bit, it doesn't require a finding that both parents neglected or abused the child. It can be a single parent. And in fact, a parent can be designated as the guardian or custodian of the minor, regardless of whether they are documented or undocumented. The one issue with the special immigrant juvenile visa is that it does cut off the relationship between child and parent for immigration benefits. So say the minor finally is able to get their residency and then citizenship, they would never be able to petition for their parent. So it's a very serious consideration for a lot of clients. Sometimes our advice is different depending on what's going on with the parent, depending on what's going on with the child. Most of the time, parents are just like, I don't care. I just want my kid to be safe. I want them to have status here. If I get deported, I don't care. I just want them to be able to be here and have their green card. As you know, like a lot of people are fleeing because their minors are being targeted by gangs, gang recruitment, cartels. And you can't really refuse them. If you refuse them, you usually die or are threatened, extorted. It's pretty bad over there, like in El Salvador and Honduras, Guatemala. So that tends to be the case. But so once you file the special immigrant juvenile self-petition, you have to do that before they turn 21 with USCIS. So again, another age consideration. So even though the 21, you can get an order up until they're 21 in a family court, you have to do it at least 2 days or a day before they turn 21 so that you can send out the self-petition before they turn 21. So you have to be really careful about ages. And then that self-petition pens and then there's a priority date. So it's under the EB-4, I think, trying to remember, but there's a long backlog. So I think right now, I'm trying to remember what the priority date is. But I think it's about 4 or 5 years. It might be longer. It varies, but so there is a priority date. So they have to basically wait until their priority date is current, and then they're able to apply for a green card. And once they get their green card, they can then apply for U.S. citizenship after 5 years. So it's a great process, especially because there are a lot of kids who are either orphaned or are fleeing abusive situations and come here by themselves. And it's a way to ensure that they are in safe hands and that they are in a pathway of having legal status so that they're not exploited further.
Yeah, I feel like that's a piece that I feel the word needs to be spread on that one, in terms of it being available to a lot of people and them not being aware. Because, I mean, it's a common fact pattern for one parent to bring a child here. The other parent is either deceased or wants nothing to do with the child. And there's nothing for that child to return home to. Also, maybe that child is at this point more American than they are, where they were born. So it'd be a huge setback for them to go back there. And, there's a path the law recognizes that this person who's still under the age should be taken care of by our country and protected. So I feel like I feel like people know about asylum and stuff. I feel like that one is, I feel like the word should be spread on that one as a great opportunity for people.
Yeah, I think what makes it challenging is the fact that you have the family court order piece. So for immigration attorneys who aren't licensed in their state, they're not able to do the whole process. So they're either having to find a family law attorney who can do that, which is another expense. And it just gets a little bit complicated in terms of streamlining the process. So ideally, I mean, we have several resources here in San Francisco that actually offer free legal services to get the order, and then they give it to your immigration attorney, which is amazing. So a lot of that I think is a funding issue as well, and just having organizations being able to provide the service. I know that when I was at Nationality Service Center, they had a fellow who was actually working on just getting orders for SIJS.
Gotcha.
Yeah.
All right. How do people that fall into these categories, how do they get work permits? How does that work?
Right. So for humanitarian, so for refugees, once they enter, they're authorized to work because they have an I-94 refugee status. It's indefinite. And with that, they're able to get a social security number and they can work. For asylum, it's different. You actually have to have an application pending for at least 150 days. There is something called an asylum clock. That clock can stop if there's any delays caused by the applicant. For example, you file for asylum on January 1st. You have a hearing January 30th. You ask for a continuance that hearing, the clock stops. So once that clock reads 150 days, you're able to apply for a work permit. And then at 180 days, USCIS can grant you employment authorization. And that authorization is renewable until you get a final adjudication on your application. For SIJS, there's deferred action for those who've been approved on the self-petition. And so that also allows them to apply for a work permit.
So that's great. So these people that are getting the work permit, they're then paying taxes just like anybody else, making their contributions, all while their application is pending, right?
Yep. And in fact, even those without work permits are paying taxes using an ITIN. There's a specific number for the IRS that the IRS gives to people who are undocumented called an ITIN. And I know plenty of people who pay their taxes through the ITIN, but they don't get a tax refund. They don't have any access to that money until they are finally in lawful status.
Yeah, because I knew the ITIN as a foreigner who owns a business here will not have a social security number, so they'll apply for an I-10. But I didn't realize that it was also used in that situation that you described.
Yes.
Okay.
Mm-hmm.
All right. Let's talk about some of the other paths to residency. Marriage.
Yes. So there are a couple of different pathways for citizenship through marriage. It depends on where your spouse is and how they enter the United States. But one of the most common ways is through consular processing. There's either the fiancé way or the marriage way. So let's start with the fiancé way, because I know a lot of people probably watch 90 Day Fiancé and know all about it, but let's just get that out of the way. So the fiancé visa is only for U.S. citizen petitioners. So you can't do it as a green card holder. You have to be a U.S. citizen. And you have to have met your fiancé in person at least once within 2 years preceding the date of filing of the petition, which is the 129F. And in that petition, you basically have to make a declaration of intent to marry. So one thing that I find really annoying with 90 Day Fiancé is that they're like, well, she's going to come here in the 90 days and we'll see if we want to get married. And it's like, no. You actually have to have full intent to marry this person. You have to make a declaration under penalty of perjury that you intend to marry this person when they get here. This is not a honeymoon phase for you to figure out whether you want to marry this person or not. And
so it's like they're here to do wedding planning, right? Almost like that.
Exactly. So with the fiancé visa, once it's a hybrid type of a visa. It's called a non-immigrant visa, but it really is to immigrate to the United States. So you file the petition, you go through consular processing, which means the petition once it's approved, it gets transferred over to the consulate that it's designated in your area, and you get interviewed. They check for any admissibility issues, like any disqualifying convictions, any past things. Could be like that. Maybe you've committed marriage fraud in the past. Maybe you've had a removal order in the past. Maybe you've have a unlawful presence bar because you overstayed a visa here many years ago. All of these things that they're screening for. And then once you enter, you have 90 days to get married. The K is a single use visa. So once you're here, you're here. You cannot leave until you either get advanced parole or your green card, whichever you get sooner. So you get married within the 90 days, and then you have to file for your green card. You don't have to file for the green card within the 90 days as well. Most people try to file it as soon as possible after they get married, because you also apply for work authorization and a travel document at the same time. And so you can imagine how difficult it can be for people who are coming here being like, I can't work. I can't do anything. Like, I can't travel. I'm stuck here until my application is adjudicated, either for advanced parole or for my green card. So people tend to try to file that as soon as possible. In addition to that, the U.S. citizen has to show ample financial support. So they have to sign what's called an affidavit of support, which is fascinating because it's basically a contract saying that you're going to support your spouse for a specific period of time and or until they become a U.S. citizen. This is something that you cannot prenup around. This obligation is enforceable. It has been enforced in divorce proceedings, and you really need to consult with a family or divorce attorney or whoever's doing any sort of prenuptial agreement to make sure that they understand that this is something that they cannot contract around. It is a obligation that you're signing and agreeing to with the U.S. government. And divorce courts, you'll find the case law, they will absolutely require you to support your spouse if you divorce or anything like that. So that's the fiancé visa process. It can be lengthy. Right now, it depends on where you are, what office is processing the visa, but the petitions are getting approved in like 6 to 8 months. To get the interview, once it gets transferred over, you can get an interview pretty quickly depending on which consulate you're in. Some consulates are busier than others. And there's also just some consulates are really still backlogged from the whole pandemic. They're working through that backlog. There were staffing issues at a lot of the consulates as well. So there are some people who have been waiting a very long time. But I have seen an uptick in processing times. So hopefully, if anybody's out there, don't lose faith. There's also the I-130 consular processing. So that is if you are married to somebody, you're already married, and that person is residing abroad, or they're here, but maybe they're on a different type of visa, or they're visiting, but they're going to go back to their home country. And so with that, you basically file what's called an I-130. Once that gets approved, it gets transferred to the consulate again. You go through the same sort of interview process that the K-1s go through. And then once you're here, you're actually a resident. You are admitted as a lawful permanent resident. You don't have to file another application to get your green card. Depending on the length of the marriage, if you get approved before your 2-year anniversary, you're a conditional resident, and then you have to file a petition to remove those conditions 2 years later. Or if your marriage is longer than 2 years, and you just get the unrestricted green card. And by say unrestricted, the conditional residency isn't restricted. It has the same rights and privileges as a regular green card. They just want to make sure that this marriage wasn't fraudulent. And so they want to sort of vet you again 2 years later to make sure that this, in fact, was a bona fide relationship. There's also what we call adjustment of status. So sometimes we have people here who maybe they're like on they're a student and they fall in love, or maybe they came here on a J1 exchange program and, they fell in love with the country, and then they fell in love with somebody and they don't want to leave. Maybe you have somebody who was here on a tourist visa and just said, I don't want to go back, and overstayed, and they've been here for a while. Some of those can adjust. The person who overstayed can only adjust here if they have a U.S. citizen spouse. But for those who have lawful entries and have maintained lawful status, they can adjust through a lawful permanent resident spouse or through a U.S. citizen spouse. There is also a difference based on whether your spouse is a U.S. citizen or a lawful permanent resident as it relates to unauthorized employment. So unauthorized employment would bar you from adjusting if your spouse is a lawful permanent resident. But unauthorized employment is not a bar if you're married to a U.S. citizen. So after getting rid of those, so the process is pretty straightforward. You file everything in one step. I-130, the application for the green card, the application for the work permit, the application for the travel document. You get it all pending. And then they used to interview, but now they're just granting without interview, which is great. Means less waiting and all of that. And then you have a green card, and you don't have to leave the country to do it. You don't have to go abroad. There is a special category, though, of people who entered unlawfully, who could still benefit from being married to a spouse, but they usually require a waiver. So there's something called a provisional unlawful presence waiver. It's for individuals who have a entry to the United States, who stayed more than a year without authorization and want to now get status. So what happens is, because they don't have a lawful entry, they have to consular process. But if they leave, they trigger a 10-year bar. So this waiver is to address that 10-year bar. What happened is that they decided to allow people to apply for and wait out a decision on the waiver while remaining in the United States. So once they get the waiver approved, then they go to the consulate, they do their whole interview, and then they're able to come in. But there is something called a perm bar, which is not waivable. So that applies to people who came here unlawfully, stayed a year, left, or either entered unlawfully and stayed more than a year, or entered lawfully but still have 1 year of unlawful presence, It can be continuous, or the unlawful presence can be in an aggregate. But if you enter again without inspection after having accrued 1 year 1 year physical presence in the U.S. without authorization, you have to wait outside of the U.S. for 10 years before you can immigrate back to the United States. That being said, with these processes, there's other waivers. There are waivers of criminal convictions. There's waivers of certain misrepresentations. There's waivers for certain illnesses. But, the waivers, you have to show hardship. You have to show hardship to your U.S. citizen spouse, to your LPR spouse, to either if your parents are U.S. citizens or lawful permanent residents. So it's not an easy burden, and it's difficult to show, especially if you have a really healthy family. But there are waivers available.
Very interesting.
I know I'm like bombarding you with all this info. I'm sorry.
No. I mean, look, everything you're saying is something that somebody could use to their advantage, hopefully,
Okay.
and to their benefit. Why don't we take some time for you to promote whatever it is you want to promote? It could be your cause, it could be your firm, your services, whatever you want.
Oh, okay. Well, Samora Law. I have a practice in San Francisco and in Oakland, California, but I also have clients all over the country. So if you find that you have a really complicated case, give me a call. I tend to deal with complicated naturalization, complicated adjustments, complicated waivers, and complicated asylum cases. So I'm happy to help, happy to see what's happening in your case, happy to offer a second opinion. I think everybody who's a non-citizen should have at least one consult with an immigration attorney to really understand what their specific situation is. There's a lot of misinformation out there. There's a lot of stuff going on TikTok, Instagram, et cetera, that isn't fully able to explain the nuances of immigration law, nor are they able to show how this law is going to apply to your specific case. Everybody's different. I have some clients who very complicated, have quite a history of criminal convictions, but under the statutory scheme, they're able to get a green card. Other people, because they just have 2 unlawful entries and a perm bar. Other than that, absolutely upstanding citizens, upstanding parents, doing everything right, paying their taxes, nothing allows them under the statutory scheme. So it's really good to know where you stand, know what kind of defenses you could have if you're ever picked up by ICE. So just remember, knowledge is power. Knowing what's on your record is power. So I highly recommend getting a consultation, even if you're going to get news you don't like or you don't want to hear. It's so important. And you might discover that there is a way to be granted, or there is a pathway forward. The other thing too is stay vigilant. The law is always changing. There's constantly new cases coming out that can actually change the scheme as it applies to you. So, try to stay on top of those things. A lot of times there's a limited period for you to sort of claim a benefit under a change of law. So it's really important to still be aware, know what's going on.
Great. And look, I have you on my show because I know if I had immigration problems or anyone in my family did, you would be the person I would turn to. Immigration law, right there, you always hear Congress talking about we need immigration reform. It feels like it's something that everyone says there's problems with, but everyone has different idea as to what the solution should be. So what is some reform that you would advocate for? If you were in power or had the ability to influence, what would you get changed that you think would benefit everybody?
Oh boy, there's a lot. In terms of like very specific laws, I'd get rid of the 1-year bar deadline for asylum. I'd get rid of the perm bar. I would increase access for people who are applying for asylum. I mean, one, I believe in open borders. I think that, there are better ways to increase security other than trying to have this very draconian sort of border situation that we have. I think also one thing that happened, during Reagan's amnesty that also was a great disservice was we had an opportunity to have seasonal, or like a whole category of seasonal worker visas here. And that didn't happen. And there are a lot of individuals who would just come here, work for a season, pay their taxes and go home. And with the increase in border security, that became more difficult. So a lot of people just have to stay here. So creating sort of that system where people feel that they can come here. There are plenty of sectors that need help, or that need people who can work. And you're creating a process where people are being screened, vetted, and then you're also, having a whole new tax base. I would do that. I would, so many things. Now I'm like having a blank. I would definitely create and expand the ability for people, sort of like how they did it with the registry back in the day, where it's like, if you've been here since this period of time onwards and you don't have any convictions, you can demonstrate you've been working, you should be able to just get status. It just, to me, it's mind boggling that we don't have that kind of a system here. Because there are a ton of people. I mean, I've had clients who have been paying taxes for 25 years, no convictions, but they just don't have a qualifying family member to fix their unlawful entry. And they're just here without anything. And to me, I think it's a real disservice. I mean, they've been pillars of their community. So those are a couple of things. But to be honest, there's really, especially on like the Republican side, there's no incentive to actually have immigration reform because it's perfect political capital for them, because the immigrants are sort of like the low-lying fruit. Immigration is like the low-lying fruit for any sort of politician. If there's something going on, create harsh immigration laws or refocus, attention to the border. It's always a winning issue for Republicans to just talk about how, the Democrats don't want open borders and don't know how to do anything. And I can't curb this crisis, and that they're sieging under, Biden. And that's just the problem. I mean, every time there is some sort of proposal, it actually has, it's really poorly written. It doesn't really understand the actual needs of how to make the system more functional. I also think that we ignore the fact that the U.S. is what kind of created the border crisis. I mean, the way we destabilize these countries in Latin America, we have a sense of accountability to these people fleeing these countries. So I would say, having a better process for them to be able to immigrate here as well. There's the diversity visa as well. But yeah, there's just a lot that can change and it can be done. People try to say, but if you do something like amnesty, then it's just going to mean that more people are just going to always come here. And they try to say that, like, it's deterrence by not having these available. But deterrence doesn't work when you're desperately trying to stay alive, Deterrence saying, like, I had a client just recently tell me that what motivated her to come here was the fact that, in Guatemala, her child literally almost died of starvation and was a day away from dying because of the circumstances of being indigenous and living in a place without access. But when I talked to her about it, she didn't even she was just kind of like, oh, well, we just decided to leave. I'm like, well, did something happen? And she started telling me this story. And I was like, that sounds like a good reason to leave. You want to keep your children alive. She was like, well, yeah. She's like, it wasn't going to be possible there. You can't deter somebody like that, where if they stay, they're going to have to see their child literally starve to death, or make the journey here and hopefully have some chance of being able to give them a better life. So, I think we really have to think about that. And, it's just a challenge, and it's a difficult area to practice law in, because you do have to hear some of these really horrifying stories. And that's why, when I see people react and just want to dehumanize these people who are fleeing really horrible situations, to recognize that, like, what would you do for your children? You would do anything. I mean, I've heard people say they would kill for their kids. So, I think we need to keep that in mind as we address and try to craft immigration laws.
Do you think part of the problem with the friction, what I see is that you have two sides that have completely, they both have different images of what this is, right? So on the right, they'll point to people that have committed heinous crimes that they argue should be here, or the person mooching off of the government or whatever. And then on the left, they'll point to, the person that is salt of the earth and works really hard and provides for their family, and they both hold these posters, these like contrary posters up against each other, and I just feel like that's why we're never going to get anywhere with this.
Yeah, and I think also, the statistics don't actually support the right side. Immigrants are known to commit crime at a much lower rate than native-born citizens of the U.S. You're actually not eligible for any government benefits if you're undocumented in the United States. What they're pointing to is, but their U.S. citizen children are going to be able to get stuff, and how dare they? That's why you're hearing this sort of nativist rhetoric. You have a candidate trying to get rid of whatchamacallit, what's it? Did you do when you're born here as a citizen? Birthright citizenship. Literally trying to get rid of birthright citizenship because of this fear of, like, this white displacement theory, which is ridiculous. So, like, these fear mongers, it's not actually based in reality. Of course, there are people who have committed heinous crimes. They're deported. I've seen them be deported. This is not, the law provides for that. But I think it is interesting that they keep talking about a resource problem, but it's like, well, then why aren't you actually just focusing all your resources on those people, as opposed to, trying to prosecute the mother whose kid is autistic and she's just doing the best that she can to take care of him. But now, like, you're spending resources on trying to remove her from the United States. Even just hearing, like, what Trump trying to say that he wants to have the most expansive deportation that anybody has ever seen. I was like, the entire system is so dysfunctional. It would be impossible for them to even execute that. It would probably result in a lot of U.S. citizens getting deported through racial profiling. It's just not based in reality.
And not only, I don't know, I feel like a pragmatist would solve this problem better than people that are truly entrenched to one side. Because, for example, something like that, even if you're vehemently against the current policies and like, you got to account for due process and all the clutter that would cause. And your end goal would not be met because of all these other things that would get in the way. Kind of like, like the travel ban and things like that. Like, even if you agree with something, you shouldn't enact something that is going to get shot down, right? Because you're not accomplishing what you set out to accomplish. Like, focus on what you can fix and versus what will just cause friction and accomplish nothing for neither side.
Yeah, but I think one thing you have to recognize, in the U.S. it's been happening in the U.S. for centuries, is that the powers that be always use immigration to keep people down. What do? They use it to destroy labor movements. They use it to, basically try to, elevate other groups over other. If you look back in the day when Italians were considered like non-starters, when people were trying to formulate unions, they would try to bring in a different group who, in trying to sort of spark this sort of conflict. So I think the biggest problem is just that, when people start operating this like tribalistic way and like thinking about like, well, my resources versus your resources. We're also just focused on the bottom, that nobody's actually looking at the top of who's profiting off of this racism and xenophobia. So I just think that like, because of that sort of history that the US has, you still have so much xenophobia. You still have so many people thinking that like this immigrant from Guatemala with no education is somehow going to take their job or take their resources, rather than looking at it more. I mean, and this is rather than saying like, oh, how about we figure out a way to incorporate people so that we have a stronger labor movement, so that we have unions. Let's actually offer union membership to people regardless of their status, so that we can have strength in numbers and do collective bargaining in a better way. Like, that's the problem, is that it's so easily utilized by politicians to be divisive and to be extreme on immigration, that, like you said, until we actually get people who really want to solve the problem on both sides, nothing's going to change. So, I keep hearing people talking, like I have clients like, oh, what about immigration reform? What about immigration reform? Like, it's not going to happen. Especially now and how things have changed. And I mean, Trump really did a number on figuring out ways to harm sort of due process rights for immigrants. One of the things that I said when he first won, I was like, he's going to stack the federal courts. And these federal courts are going to issue rulings on immigration policy that are going to be so bad. I mean, you see the Fifth Circuit all the time issuing decisions saying that the president doesn't that Biden doesn't have the authority to have priorities on enforcement. Like, what? How is this Fifth Circuit judge telling the president that he can't have priorities in immigration enforcement when that's under his purview? It's just mind-boggling. So there's just a lot that's going to happen if he wins another term. I have a feeling immigration is going to get really messy. I'll be here for direct legal services if anybody needs help. But it's going to be a challenge for sure. And you're going to see them utilize a lot of tools like expedited removal, which does enable them to remove somebody without really any due process considerations because they already have a removal. They're probably going to try to do that at the border again. I mean, there's just a lot of bad stuff that would be on the horizon.
All right. Well, Marla, thank you so much for your time. I believe that anyone who listened to this has something to take home with it, and a lot of people can use these things to their benefit.
I hope so. Like I said, knowledge is power. And for all you criminal defense attorneys out there, you have to give advice, specific Padilla advice. Okay. And like I said, you can contact me. My firm is samoralaw.com. All my contacts there. Also, I do want to give a shout out to Nationality Service Center in Philadelphia. That's where I started my career. I love them. They also offer great legal services. So if you are lower income, struggling to pay for an attorney, you should definitely call them.
All right. And we'll put your info and that info in the show notes as well. So if you're needing, if you're in need of an attorney, now you have someone to call. To all my listeners, stay solid and subscribe to my podcast.
Need a lawyer? Are you having financial, criminal, or family challenges? Call or text the Mark Kachi Law Firm, 215-439-7899.